Malar, and today I'm going to present about the history of international business law. In its most basic form, trade defined as the exchange of products, services, or both. Commerce is another term for trade. Barter, or the direct exchange of goods and services, was the real face of trade. Traders nowadays usually negotiate using a medium of exchange such as money, which separates buying from selling or earning. The invention of money facilitated trades. Bilateral trade is a trading between two traders, whereas multilateral trade is the trade between more than two dealers. There also have three stages in international trade, which is trade in the past. Before the beginning of modern currency, prehistorical people used trading as their primary means of exchange, bartering goods and services with one another. Secondly, trade during Middle Age. People, cities, states have traded since antiquity, but during the medieval age, goods were transported over wider distance by land, river, and seas. Thirdly, trade during modern age. Same as before, except with today's technology. We can track our goods using systems or apps, which is more convenient and take less time. Thank you, and I pass to the next person to present.
Hi, my name is Divyasri and I'm going to present my part, which is nature of international trade law. So the international trade law includes the appropriate rules and customs for handling trade between countries. So the main purpose of international law is to promote justice, peace, and also common interest. Nature of international law, trade law can be classified into two groups, which is public international law and also private international law. For the public international law is regulated by first thing first, customs that are included as state practice and opinion juries. For the second thing, treaties, and also for third thing, globally accepted norms. And for fourth thing, it regulates the relationship between those nations and people that may be affected by a particular law as they feel to be bound by these legal codes and rules. For the second law, which is private international law, is the area of law that comes into play whenever a court is faced with a question that contains a foreign element. So the presence of such a foreign element in a legal matter raises a number of questions, and it is the function of private international law to provide an answers to these questions and to ensure just solution.
Strategy of international business law is a rule established by the government to conduct of individuals in groups to protect the individual itself, to the society and to the property. Sovereign states have their own rules and foreign affairs. For them to do a domestic law and laws of the foreign country itself, conducting businesses between international. International law is providing a regulation. International law transaction itself from one nation to another. General Agreement Tariff and Trades, or GATT, is to promote multilateral, fair trade and reduce trade barriers between national and national, between nation and nation. Members of GATT is to reduce trade barriers from granting most favored nation. Tariff or duty within the country itself is an important sources for the country as an income to safeguard domestic interests, and the countries may resort to most important things. Intervention or creation protected by the copyrights and patents. Copyright laws give authors, artists to control the reproduction and performance of their work.
Hello guys, my name is Shazwan and today I want to present about all legal principle. Let's go. Legal principle, the easiest way to define a legal principle or legal responsibility is to first understand liquid meaning, words and expression. Legal principles are defined as a standard or set of standard of conduct or consideration that assume to be fair standard of conduct for society or all human beings. Legal principle also can represent the general consensus of basic society. Understanding is a kind of default rule of conduct that cannot be changed by fair and hot decision for any state of body. Okay, the practice of use of a legal principle. The principle of law is the most useful source of law, not forming a perspective on the high rate of use a source of law, but because it is its important role as a standard of generalization used to justify and validity of other written source such as law and subordinates. Second point, legal principles are the only source of law available to judge when dealing with relationships that are not governed by any positive written law, since ancient Rome judge will not allow any justice based on the agreement that there was no law government relations in this scheme. Last point, general legal norms of international law are norms accepted and recognized by the international community of a state of a whole as norm for which no reduction is permitted, which can be modified of general international law having the same character.
My name is Parmeswari and today I am going to present about the sources. So the first source is about agreement between state. Okay, agreement between state is a person sells good to another state of person. Okay, for an example, Ahmad sells his handphone to another state of person. When he sends the good to another state, the procedure and the law will be different compared to the states, and it's already given by the agreement too. There are two types of agreements. The first agreement is bilateral. Bilateral means agree by two countries only. Okay, for an example, when an offer a goods to another country, both countries should agree and accept the agreements before the goods proceed to ship. And the second agreement is about multilateral. Multilateral means every country agrees is important before they proceed to do the work. For an example, Paris country was destroyed by climate change. The Paris country was destroyed by the climate change, as I said before. Every country agrees is important before they proceed to do the work and to work together to change the climate. And the second the second source is about general practices between states. So the general practices between states is when a goods shipped to another country, the custom department will check before they proceed to ship. For example, requiring states to grant immunity and to the head of the state. And also there are two elements. The first is widespread and the second is a consistent state practice. State must in general have a practice according immunity to a visiting head of the state. Secondly, usually a belief in legal obligation. For example, state must accord immunity because they believe they have a legal duty to do so.
Hello, my name is Nur Kamarina and I'm gonna talk about Social 3 and Social 4. Social 3 is general recognized principle law. Principle of law are fundamental rules whose content is general and abstract, occasionally reducible to essential or a simple conception type of rule similar as legislated law or agreement. For example, like there are a type of cases that in Social 3 that is criminal cases and civil cases. For the Social 4 is previously decided case and academic wings. The number of Supreme Court judges is left to Congress at time there have been as many as 6 or as many as there are, while the current number has only been in place since 1869. For example, case law from Chin Chun Yen and Anor 2020 5 AMR 541 FC. That's all. Thank you.
My name is Wilson. Today I will talk about source 5, 6 and 7. Source 5 is agreement between traders. Agreement between traders is a contractual agreement between countries or trade relationship. The trade agreement can be bilateral or multilateral, which also between no states. Example, healthcare companies regularly use trading partner contract to exchange their both goods and data. Okay, the next is Law 6, is domestic law. The state established law or legal system for governing state or state-related events, transactions, and individuals. Example, Malaysian Sale of Good Act 1957. Okay, the last one is Source 7, that is dominant commercial organization practice or rules. Okay, it is an organization which having a large amount of marketing shares in worldwide. Example, Petronas company. Because Petronas is an integrated international oil and gas company, and it also operates among the top oil and gas company in the world. That's all, madam. Thank you.